Hello everyone. Today I would like to speak on the services component of the India-Australia FTA, the structure of the services agreement, and the negotiating issues that have either cropped up or will crop up during the course of these negotiations. Now, we all know how critical the services component is for both the Indian and Australian economies, and therefore, a balanced, ambitious services agreement would be critical for the success of this trade agreement. Now, in order to better understand some of the issues, it would be good to have a look at the structure that has been followed by both countries in FTAs that have been signed by them either in the recent past or even historically. Let me begin first with India. Now, India in its FTAs has used almost entirely the GATS approach. There have been a slight GATS plus language in a couple of provisions, but almost entirely India has borrowed from the GATS structure. Now, this of course means that India has followed the structure where all four modes of supply have been covered under the services agreement. Unlike in many FTAs signed by countries including Australia, where Mode 3 or commercial presence has become part of the investment agreement. It is India's firm belief that services commitments need to be in one uniform place for it to make sense to businesses. And at the end of the day, business decisions are often a mixture of various modes of supply. So if the commitments are spread all over, it would be difficult for businesses to understand what kind of commitments have actually been undertaken. There is a separate chapter on MNP, which is the movement of natural persons. Now, this is, of course, critical for India, but I do believe it's equally critical for Australia. And I will talk later about the components of this MNP chapter. Now, because there has been an investment chapter in many of the FTAs that India has signed, there has also been a link between the services and the investment chapters. By ensuring that the investment chapter does not cover measures that relate to trade in services or movement of natural persons. But at the same time, it is important to protect the rights of investors of service sectors, and therefore the normal protection rights like minimum standard of treatment, compensation for losses, expropriation and compensation, subrogation, settlement of investment disputes apply mutatis mutandis to any measure of supply of service through mode 3, provided they relate to investment and to obligations under the investment chapter, irrespective of whether they have been scheduled or not in the services commitments. Now, because of the CAT structure that has been followed, India has used the positive listing approach in its FTAs. Let me say here that intrinsically, there is nothing to be said about the level of ambition of positive or negative lists. It all depends on the content. There is every possibility that a positive list FTA could be extremely ambitious, and a negative list FTA with a very large list of non-conforming measures could be far less liberalizing. So therefore, at the outset, I don't think the decision of whether to take a positive or a negative list is necessarily linked to the level of ambition. Ambition comes from the substance, the depth and breadth and scope of commitments that are undertaken, and the kinds of restrictions that are or not maintained. Secondly, there has been no ratchet mechanism that has been used. In other words, particularly for developing countries like India, the FDI policy is evolving. And as we develop our regulatory regimes, as independent regulators set foot, liberalization also proceeds parallelly. And therefore, a lot of FDI liberalization has already happened. India has one of the most liberal FDI regimes in the world. but that there is still scope for improvement, and therefore we have not followed the policy of automatic ratchet effect. Future liberalization, if it is undertaken, would be a matter of negotiations and subject to mutual gain and balances. These commitments can be obtained by the trading partner in future. Similarly, is the case for MFN. If, for example, India signs FTAs with other partners subsequent to its FTA with, say, Australia, and a more liberal commitment is made in a particular sector, it will not automatically extend to its previous FTAs. It will again have to be negotiated, and as I said, is a matter of mutual balances and gains. Now, India's trade in services chapter, as I said already, is the GATS language. There are some notable additions, particularly in the part on recognition. Now, given the importance of professional services and the problems that arise for market entry of professionals, largely relating to qualification and licensing requirements and procedures, it is obviously, therefore, no surprise that there is some additional language used in this particular article. It basically exhorts the professional bodies of both trading partners to negotiate MRAs in sectors like architecture, engineering, nursing, medical, dental, etc. There is also a certain time period that is mentioned in the Indian FTAs, ideally 12 months, and the professional bodies are supposed to negotiate within this time period. Now, this is something which is in Australia's interest as well, and Australia has also used it. For example, in its FTA with Indonesia, it certainly has a separate annex on professional services. The RCEP has a separate annex on professional services, whereby language, similar language for MRAs is used. And then, of course, as I said, there is a very substantive chapter on movement of natural persons, which lays down the definitions, the conditions of entry for various categories of natural persons. Some of these categories are linked to commercial presence. For example, intra-corporate transferees. There are others which are de-linked with commercial presence, like contractual service suppliers and independent professionals. And then, of course, there are business visitors. Now, the categories of business visitors, IPP and CSS and intra-corporate transferees are common to commitments across many FTAs by many countries. What might be slightly different is the inclusion of the term independent professionals, though this too has been used by several countries in both their WTO and FTA commitments, and I'll come to details at a later time. The last part of the structure of a services agreement relate to disciplines on domestic regulation, that there are different ways of doing so. You could have specific disciplines on, for example, qualification requirements and procedures, licensing requirements and procedures, technical standards, transparency, etc. Or, as we mentioned, you could do it through trying to develop equivalence or methods of recognizing each other's qualifications, and the best way of doing so is through MRAs between the professional bodies, which largely do this job of determining equivalence or recognition of qualifications, holding of professional exams, and so on. Looking at the Australian case, and particularly if we look at the FTA, sort of the RCEP negotiation, the commitments in the services chapter are based on negative listing for most participants, though of course there is a provision that participants who would like to use positive listing at the time of entry of the agreement would have to make a transition within 6 years of this date of entry to a negative list. Now, there is a ratchet mechanism, there is an automatic MFN, So many of the negotiating structures which are absent in the FTAs that India has signed are, on the other hand, present in the FTAs that Australia has entered into. And obviously, as a starting point, this is a matter of divergence, but this does not necessarily mean that there is no element of convergence. There is certainly an element of convergence. We need to appreciate the reason behind a particular approach being followed. There are very critical issues, for example, why India has not been able to use negative listing because of the huge volume of measures that would be in place at the central, at the regional. It's a federal government, and India has more than 30 states. So to try and have a complete universe of all these measures and to bring about annex of non-conforming measures is not easy. And as I said, the level of ambition is by no means determined by whether you have followed a positive or a negative list. The Australian approach in prior cases has always been of using mode 3 in the investment chapter, but it is likely that investment will not be part of this trade agreement. If at all, it would be a separate agreement to be negotiated as a BIPA, and therefore the structure which India has used of all four modes of supply being considered in the services commitments seems to be the one that is likely, and therefore this problem is not likely to arise. And of course, there would be the linkage between the services chapter and investment chapter, even if it is, for example, separately negotiated and is not part of the SICA per se. Uh, as terms of some of the negotiating issues that are going to be critical, I think MNP also will obviously be an important component, but certainly not the only one. Uh, I do see synergies between the Indian and Australian side. The Australians are short in a number of skills, both short term and medium term, and they do have these temporary short term skill visa, which has replaced the 457 category. And here I think a lot of synergies are possible. India should be able to fulfill this demand gap of Australia. And in fact, one should be dynamic and futuristic and project the kind of skill shortages that Australia is likely to face over the medium long term. And if India is in a position to supply such skilled personnel, then there should be a program for doing so, including a program of training, skilling, and certification. And this should be to the mutual interest of both countries. Uh, as far as mode 3 is concerned, I do see not too many problems in the sense that mode 2 regimes are fairly liberal. Commitments, of course, will be determined by the extent of balance and mutual gain. As I've said previously, India has one of the most liberal FDI regimes. Some of the key sectors, like, for example, you have 100% FDI in telecommunications. Recently, 74% FDI has been allowed in insurance. The banking sector is again fairly open. You have more than 51% for private sector banks. As far as single brand retail is concerned, 100% FDI is allowed. Only for multi brand retail, 51% is allowed. But there are sensitivities in the retail sector because of the huge unorganized sector in India. And a critical segment of this unorganized sector are the small traders, the neighborhood shops, the kirana shops, as they are called in India. Which obviously provide a lot of employment to people, and therefore there are livelihood sensitivities regarding displacement of such small traders and neighborhood shops. Uh, as far as I said, the telecom IT sector is concerned, we are completely open, probably one of the most liberal regimes in the world. Our strengths in software, in the entire range of IT related services, including the newer services, is well known. Again, this is something that Australia should be able to provide certain commitments. At the same time, professional services are important for both of us. Both in India and Australia, we have thriving professional services, and we should be able to provide reciprocal commitments or opening up in some of these sectors. And as I said, it has to be backed by disciplines on qualification and licensing procedures and requirements, because unless we do that, even if market access is granted, what is achieved through one hand will be taken away by the other. And therefore, that brings me to the last point, that domestic regulatory disciplines must be a critical part of the services agreement that you are negotiating. You could follow the disciplines that are being developed or were being developed in the WTO, unfinished business of the Working Party on Domestic Regulations. You could take certain elements from the JSI on DR, particularly the transparency and good governance issues, and you could also have the usual attempt to negotiate MRAs between professional bodies and try and fix certain time limits within which you would expect them to do so. And you could name a few professional sectors where you believe the best chances or the best possibilities are of negotiating such agreements in a time bound manner. But not to forget cross border supply. And this I've kept at the end because this is something which I believe now India and Australia both have a lot to gain. In a post pandemic world, digital or cross border supply is becoming almost the dominant form of services supply. Not just services supply, many form of merchandise goods is now being converted into digital form and being sold or serviced accordingly. Now, cross border commitments in modes 1 and 2 therefore become critical. We know that actual restrictions in the ground in these modes are far lower compared to modes 3 and 4. And therefore, it is in the interest of both countries to try and lock in their current regimes. There are not too many national treatment restrictions, and therefore, it should be possible to take national treatment commitments as well. One common refrain that is often there is the prior presence of commercial, is the prior requirement of commercial presence. Now, it is something which one can understand for prudential reasons in financial services, where there would be jurisdictional issues if there is no commercial presence. But in other sectors, maybe there is need to relook at this restriction that is often put in mode 1. Further than that, with technology, now virtually every service except a few can be delivered digitally or electronically, and therefore there is no need to take commitments of the kind unbound due to technical reasons, which we have often done in the past. And therefore, liberal breadth and scope of commitments in cross border supply should serve the interests of both India and Australia. Now, these are some of the critical components. On some, there is convergence, but as is the case with any trade agreement, there are different degrees of divergence in many of the other issues. And it is really the challenge for negotiators to be able to find middle ground and balance where such divergences exist. Thank you.